Evicting a tenant can seem like a complicated process, but in this video, we'll quickly explain eviction laws in California and how to recover your property in 6 simple steps. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks or physically remove a tenant themselves. So if the renter refuses to leave after violating their lease, you must seek an eviction from the court. Legal reasons for eviction in California. A landlord only has grounds to evict a tenant for reasons allowable in the state. The first step in the eviction process is to give the lessee one of the following notices. Non-payment of rent. If the tenant is late on rent, you can serve them a 3-day notice to pay or quit. This gives your lessee 3 days to pay rent in full, along with any penalties, or vacate the property. Curable Non-Compliance. If the tenant violates their lease, this notice gives the tenant 3 days to either comply with the lease or vacate the property. Incurable Non-Compliance. This notice is for violations that the tenant is not given the chance to remedy, such as illegal acts. It gives the tenant 3 days to vacate the property. Rent grace period. In California, there is no rent grace period. Rent is due on the due date. An eviction notice can be served if the rent is only 1 day late. 6 steps to legally evicting a tenant in California. Serve the notice to quit. Choose the form you need and download or fill it out on eForms.com. Post it on the tenant's door and also send it via certified mail with a return receipt requested via USPS. If the breach is curable, you must wait for the specified number of days to give the tenant a chance to fix the problem. File eviction papers with the court. If the tenant doesn't fix the breach and remains on the property, the following documents should be filed in the court in the county in which the property is located. Complaint, cover sheet, summons. Serve the court documents. The tenant must be served a copy of the documents by a civil process server. The process server must fill out a proof of service form and provide it to the landlord to file with the court. Wait for a response. The tenant has 5 days to respond to the court if they were served in person. Otherwise, they'll have 15 days to respond from the date the summons was mailed. The tenant must respond by filing an answer. Judgment. If the tenant responds, a hearing may be set. If the tenant does not respond, you can ask for a default judgment from the court. You will have to fill out the following 3 forms in order to have the court authorize eviction. Request for entry and default judgment. Judgment for unlawful detainer. Writ of possession. Removing the tenant. Once the court approves the writ of possession, and if the tenant does not vacate after a judgment in your favor, you can contact the local sheriff's office to remove the tenant and their possessions. Damages. Often the tenant's security deposit does not cover total losses. If the damages are not awarded at the hearing, you may be able to recover past due rent and court fees through small claims court. Now you can get eviction proceedings started. Get eviction forms, court documents, and all other information you'll need at the link below for free.